So joining me now to talk about all of this and to try to sort it all out is Glenn Smith, emeritus professor from Cal Western School of Law. Thank you for joining us, Glenn.
Oh, you're welcome. Thanks for covering this important story.
And so much to talk about because it is complicated. A lot of people asking why the president made this move now, with House Speaker Johnson coming right out to say it is dead on arrival. What is involved legally to make these changes to the High Court?
Well, as you said very nicely, the change in 18-year terms could be done by legislation. There's questions about whether that would be constitutional, but certainly and changes in the practices of ethics and recusals and all that could be done by legislation too. It may not be politically possible in the short term, but I think it's important for someone, especially of the president's longstanding experience with the court on the Judiciary Committee and his stature, to be proposing it. Sometimes good ideas take a while to take hold.
And certainly people already saying today, at least, it puts the ideas in the voters' minds before November. But just with you as a legal perspective, if every president essentially puts two justices on the court and then they term out after 18 years, how does that change the future court from a legal perspective?
Well, I think what it does is, first of all, it helps to, ironically, it politicizes appointments of Supreme Court justices, but it makes it more regular, and people can't play games with the number of justices and the vacancies as we've seen happen in the past. And so I think it creates more of a reliable credibility that the court reflects in an ongoing way changes in American society and American law. And it certainly would mean that every 2 years we're getting the injection of a new member from the law and the society. And so I think it keeps the court updated.
And we all know revelations of accepting gifts coming out recently with Supreme Court justices, relationships with people involved in cases that then go before the High Court. What legal options, if any, are there to put restrictions on Supreme Court justices?
Well, the option is for Congress to do what it's done with lower courts, which is to pass legislation. There is a question about whether, when Congress tries to legislate its co-equal branch, the Supreme Court, there are greater constraints, but there are, well-established ethical principles and laws and policies that could be brought to bear on the Supreme Court. As for justices not participating in cases where, because of gifts or other activities of theirs, their spouse or whatever, that creates a reasonable doubt as to their impartiality, that already exists under federal law, and it would just have to be beefed up.
All right. Your legal expertise much appreciated this afternoon. Glenn Smith, thank you for joining us.